supervision vigilance matter, my lord. The bank account kept on frozen since 4 years. The person is now retired. Along with this present petitioner, the entire family's bank account kept on frozen, my lord. Specifically, actually.
Pardon to make a mention, my lord. I pray for listing of a criminal appeal in vigilance matter. I have filed an IA for stay of conviction on the ground that other co-appellants case the same benefit has been granted, and the petitioner is a pensioner. Obliged, my lord.
Appellant convicted under Section 376 POSCO Act by Special Court of Conjure and more than 7 years in jail custody. Paper book ready for hearing.
You are filing for hearing of the appeal? No, then you are to wait. You mention it next week, okay?
Pardon to mention, Lordship. The matter, it's a bail application. It is a tag of matter.
Please,
Because
please.
actually, the matter was lastly listed on November.
Give the memo.
Yes.
Yes.
In several occasions, it has not been made.
Yes.
Pardon, Your Lordship, CRLA number 489, Your Lordship. This is for reconstruction, Your Lordship. What happened? This file was missed and it was not restored, Your Lordship. And meanwhile, another co-convict has filed JCRLA, preferred JCRLA, and he have gone in 2 times released on bail interim.
Give it.
Pardon to mention, Miller.
Pardon to mention. Another CRLA,
Criminal appeal
536, Your Lordship, of 2015, Your Lordship. The petitioner have in custody since 10 years, Your Lordship. More than 10 years.
Hearing of the criminal law next week.
Pardon to mention item 42, my lord. Can take it up next week, my lord. I've taken consent.
Mention when the matter reaches. Don't mention. Yes. Yes, Mr. Moon. Mr. Moon, please unmute yourself.
Lord, I am being. Am I audible, Millard?
Yes, now you are audible. Yes.
Millard, Criminal Appeal 971 of 2019. Your Lordship adjourned this matter on 21st September 2023 to 25th September 2023 to be taken up at 3:30 p.m. It was not listed and it has not been listed thereafter.
What purpose you are mentioning? What is this criminal appeal for?
Criminal appeal, it was listed for orders, Millard, release of document. The appellant has died. His widow has prayed for release of the bank documents and LIC documents so that she can withdraw, get some money for maintenance.
Okay. All right. What is the number? Noted down. All right.
971 of 2019.
All right. It is noted down. It will come next week. Yes.
Maybe on Tuesday, Millard.
We'll see that next week it will come. Yes.
Supplementary list item number 1.
Ignite the acquittal of the Reliance Special Court for PO Act, Kotak, my lord. Facing the judgment, my lord. The accused persons, namely Vijay Kumar Pradhan and Vijitra Kumar Naik, Vichitrandra stands charges under section 341.
Who is appearing for the respondent number 2? You are there.
Copy have
You
copy
have not received the copy. Serve a copy of the appeal memo along with the impugned judgment. Let a copy of the appeal memo along with the impugned judgment be served on the learned counsel for the respondent number 2 during course of this week. And is a SC/ST appeal under offense under SC/ST Act.
My lord.
So you have received the copy of the appeal memo, Mr.
Yes, Mr.
Copy of the appeal memo.
Yes, Mr.
Okay. Put up this matter in the week commencing from 27th March. Yes.
item number 4, Item number 6.
6, my lord, against the order of rejection of 205 petition, SC/ST Act is involved in this matter, your lordship. Annexure 9 is the rejection order of the
It is coming for the first time.
first time, my lord.
So serve an extra copy.
Somebody is appearing.
Huh?
Yes, but like.
No, this is my associate.
Oh,
It
sorry.
is item number 6, Mr.
6.
So it has not come earlier.
First time.
First time it has come.
Right.
And it is a 1cc case arising out.
Notice, that is why I'm sending notice soon. So extra copy we served on the land council for the state, which will be sent. It arises out of a complaint case which was sent to a police station and the FIR was registered, right? That concerned.
No. It was not sent to
Not
police
sent
station.
to.
Then what is the
Directly once his case was filed
okay?
before the special judge SC/ST Baleshwar.
Okay, so what is the address of this respondent number 2?
Millard, I have stated.
It is police station is Jaleswara, at IIC
Police station is in
Jaleswara
Jaleshwar, your lordship.
for its service on respondent number 2. Put up this matter immediately after the notice is made sufficient.
I'll take notice or I'll.
No, you just serve an extra copy, okay? Extra free copy of the order be handed over.
Further proceeding, your lordship.
It will be listed immediately after the notice is made sufficient. Okay. Give a date. Release this matter in the week commencing from 2nd April 2024. The Land and Council for the state shall produce the confirmation letter regarding service of notice on the respondent number 2 in the court. Okay. So,
Item number 7.
I'm in BC, my lord. I'm in BC, my lord.
the appellant is convicted under section 22B and also sentenced to undergo the imprisonment for 10 years with a fine of rupees 1 lakh.
There is a delay, my lord.
Yes, there is a delay. I have filed a delay application.
Where is that delay application?
120 days delay.
Why? Flag Y. Okay. Yes, Mr. Tripathi,
Yes,
it's a conviction matter and let the delay be known. Other defects you have removed.
Yes.
All right. There is an application for condonation of delay. The stamp reporter has pointed out that there is delay of 124 days in filing this criminal appeal. Considering the averments taken in the interim application, and after hearing the learned counsel for both the party, since substantive sentence of 10 years
Yes.
has been imposed on the appellant petitioner, I'm inclined to condone the delay in filing this criminal appeal. Accordingly, delay is condoned. Hard admit, call for the trial court record. What about further application you have filed?
For bail.
Bail.
Yes.
So how many years you are in custody?
Since 22, my lord, I am in custody. Though there is a 10 years, but 2 years some more. 26/3/2022. I am in custody.
Copy to be supplied. Delay condoned. Admit. Yes, next case.
Item 13.
Mr.
Item 17, Miller, we have to file an affidavit regarding the delay, but the IIC is not available. So let it come on next week. I will file it. 320.
Okay, 320 days, right?
Yes.
So objection, if any, to be filed to the IA. What is this criminal appeal for?
20B2C.
To B2 of C of the NDPS Act.
Sentences?
10 years.
So if you are not filing, why let the delay be condoned? It's a criminal appeal, 10-year sentence is there.
Yes, sir.
Lekon. In spite of giving an opportunity to the Land Council for the state to file objection, if any, to the interim application for condonation of delay, no objection has been filed. After hearing the Land Council for both the parties and going through the averments taken in the interim application, and since it's a case of conviction, where how many years?
10 years.
10 years. 10 years substantive sentence has been imposed. I'm inclined to condone the delay in filing this CRLA. Accordingly, delay is condoned, IA is disposed of, hard admit, call for the trial court record, interim applications for bail and stay realization of fine to be considered after receipt of the trial court record, deposition copy to be supplied. Say 20B2C.
Yes, sir.
How many years you are in custody?
4 years, 8 months.
Okay, Land Council for the state shall produce the custody certificate. Yes.
Item 18.
Notice was issued, matter to be
The certificate is not filed.
You are supposed to file the surrender certificate. Your client surrendered or not surrendered? Not surrender after availing the interim bail period. Okay. The learned counsel for the appellant submits that after availing the interim bail period.
My lord, in this regard, last occasion, lordship call for the report.
Oh. Where is that report? Not
On
received.
15 to 25.
Status report was called for. That has not been received. Asini. Right. Status report which was called for as per order number 5 dated 15 to 2024 from the London Trial Court has not been received. Let a reminder be sent to the concerned court to send the status report by 20th of March 2024. Put up this matter in the week commencing from 27th March 2020.
Okay.
Item 21.
May I please, your lordship?
You have received the deposition copies.
My lord, deposition copy not served, my lord.
So supply the deposition copy to the State Council.
One of the offense is 376 AB, my lord, notice to go, my lord.
अच्छा, notice आई नहीं?
No, my lord.
No, there is a direction that on 28/2/2024, order was passed that an extra copy is to be served on you.
But till late, no extra copy
It
served.
has not been served.
Mm.
All right, the Learned Council for the state submits that in spite of the order dated 28/2/2024, the extra copy of the appeal memo along with the impugned judgment and interim applications have not been served on her, for which notice could not be sent to the concerned IAC for its service and the informant. Let the Learned Council for the appellant comply the same during course of this week. Learned Counsel for the appellant seeks for an adjournment, put up this matter on such and such date. Learned Counsel for the state on receipt of the extra copies shall obtain instruction regarding sufficiency of service of notice. So for the stay realization of fine, it is allowed.
Deposition copy also not served, my lord.
The deposition copy to be supplied, yes.
Item 27.
Please.
Yes.
Yes, I am, your lordship.
Yes.
Just now serve the deposition copy.
Learned counsel for the appellant served the deposition copies of the witnesses on the learned counsel for the state in court today, who seek some time to go through the same court of this matter on 18th March 2024. Obligations.
Now 30.
condonation of delay in filing of the appeal. There's a delay
101
of
days.
101 days for which I have sought for condonation.
You have filed your objection?
Yes. First, my respectful submission is that the matter which is under consideration was before your lordships in Criminal Appeal 647 of 2022. Certain accounts had been frozen, my lords. And a petition was filed by me in the OPID court for those accounts to be defreezed. In my petition, my lords, erroneously, two of the accounts, the numbers were wrongly given, my lords. The state filed an objection to that. They also did not point out that the two numbers were erroneous and they had not been seized. And due to oversight of my counsel also, they remained in that manner. And the petition was dismissed by the OPID court. Against that, I came up before your lordship, and your lordship allowed my appeal. Criminal Appeal 647. Then, my lords, after it was allowed and I went to the court below.
Allowed to the extent?
That I will furnish, that those accounts will be defreezed, my lords.
Okay.
This is your lordship's order. Your lordship directed that the bank accounts of the appellant freezed as per the list furnished in the petitioner be defreezed subject that I give an undertaking within 4 weeks indicating the period by which work of the uncompleted buildings will be completed.
Okay.
Now, in the meanwhile, everything has been complete. They were complete, my lords, almost complete by the time
What you are challenging here?
Yes, I am telling you. After your lordship passed this direction, I went to the court below, my lords. And the court below allowed defreezing of all those accounts. But two of the accounts could not be defreezed because of the error in the numbers, my lords.
Okay.
So therefore, my lords, I filed a petition before that court again. And that having been rejected, the present appeal is against that order, my lords.
Okay. So, no, first about this, since it has come for condonation of delay.
Yes.
So, what is your any serious objection regarding?
I already filed the objection, my lord.
Okay. IA number so and so. This is an application for condonation of delay. The stamp reporter has pointed out that there is 106 days delay in filing this criminal appeal. Planning Council for the Special Counsel for the State of Odisha has filed the objection to the delay condonation petition. After hearing the Learning Council for both the parties and going through the amendments taken in the petition, so also the objection, I am inclined to condone the delay. Accordingly, delay is condoned. Then
let it be admission.
It will come for fresh admission. And you obtain, if that is this thing, if already an order has been passed for defreezing the same, merely because a wrong number has been issued, given, and he wants to correct that number, it's right that he might not have power, he has done it. But now if you find that the correct number has been furnished, so what would be the difficulty or what would be your objection? Take that instruction so that it can be disposed of on the next date. I'm taking up this matter next week for admission.
1 week after that, yeah.
Okay, you obtain instruction. This much, what Mr. Panda said that it has, have you got that earlier order in? Okay, then take instruction.
I also present here.
All right.
I also present here.
Just ask him to take that instruction.
Yes.
All right. The Mr. J.P. Patra put up this matter in the week commencing from 27th March 2024. Under the heading.
It will be 1st of April.
Okay, 2nd April. 2nd April 2024 under the heading of fresh admission. Yes.
Oblige.
Item 32.
अच्छा with hasibo ara item ta se a order ta pass hala 23 re it will be listed with CRL 647. Yes, next.
Item number 33.
Item 33, my lord, on wave matter SP Das kindly taken up 1 week after.
1 week after. You have supplied the deposition copy.
No, my lord, deposition copy not.
You supply, will take a Lord and counsel for the appellant undertakes to supply the deposition copies of the witnesses to the Lord and counsel for the state within 1 week. 1 week put of this matter on such and such date, 2nd April.
Public.
Item number 34.
Item 34,
This criminal appeal for
Conviction.
conviction.
My lord.
What is the sentence imposed?
10 years.
10 years, my lord.
I'm condoning the delay.
Right.
IA number so and so. There is an application for condonation of delay. Stamp reporter has pointed out that there is delay of 53 days in filing this CRLA. After going through the averments taken in the interim application, hearing the land and counsel for both the sides, and since it's a case of conviction in which substantive sentence of
10 years.
10 years has been imposed, I'm inclined to condone the delay. Accordingly, delay is condoned. IA is disposed of. Hard admit, call for the trial court record. Deposition copy you have supplied.
No.
Acha, interim applications for so and so, stay and bail to be considered after receipt of the trial court record. Let the land and counsel for the appellant supply the deposition copy of the witnesses, the land counsel for the state in the meantime. Yes.
Oblige.
Item 40.
40, Mr. R.C. Swain. What is this criminal appeal?
Copy not across.
2013 appeal it is pending. What is the prayer in this appeal? We know. Okay, the accused has been acquitted, and what is the offense here? All right, take down. None appears for the appellant, so also for the opposite respondent number 2. The land and counsel for the state is present. This criminal appeal has been filed challenging the order of acquittal of the respondent number 2 by the London ad hoc additional session judge fast track court number 4 Cuttack, dated 10/8/2011, passed in sessions trial case number 374 of 2009. The case has already suffered 11 adjournments. Accordingly, the criminal appeal stand dismissed for non-prosecution. Yes.
Item 41.
Here it is a check against the acquittal order they have come, my lord. On 4/3/2024, lordship were directed to file a fresh cause title, excluding respondent number 3.
All right, none appears for the appellant. This criminal appeal has been filed challenging the judgment and order dated 26/3/2016, passed by, you are there?
Item 40, my lord.
Huh?
Pardon me, my lord. Item 40.
40 has been dismissed for, you are for whom?
Mr. R.C. Swain conducting counsel for the
You are for whom?
for the appellant, my lord.
I file a restoration application, we'll see. Yes, challenging the order dated so and so. Judgment and order dated 26/3/2016, passed by the London Additional Session Judge Bhubaneswar in criminal trial number 195 of 2014. in acquitting the respondents number 2 and 3 of the charges under section 307 by 34 of the Indian Penal Code. The criminal appeal stands dismissed for non-prosecution. Yes.
Item 42.
I pray for adjournment.
Adjournment.
Adjournment. And
What is the CRLA for? Conviction or acquittal?
494 acquittal.
Acquittal order.
Acquittal.
So,
I have also
why?
intimidated the other side.
Huh?
I have also intimidated the other side to take time.
No, 2016 acquittal order, why it should be there? Either you argue or not argue. Right, I'm granting adjournment for 1 week, no further adjournment.
Oblige.
The Learning Council for the appellant seeks for an adjournment and submitted that he has already taken the consent of the respondent counsel.
And for the opposite petition.
The nahi chhad diyo seta kati diyo last line. The Land Council for the respondent is present. Put up this matter next week. It is made clear that no further adjournment shall be. Yes, next.
Oblige.
Item 43.
May I please, Lordship? My petition for petition is rejected by the Learned Additional Judge, Lordship. This petition file release of my seized articles, Lordship, some silver, 2 silver bars and some pounds, Lordship. I was shown in that case as a receiver stolen property.
Wait. Let me see that what of previous orders have been passed. Now the record is not available because of the passage of time.
Lordship, record accident.
I had called for the trial court record, the original case record. That is now not available in the court. The additional session judge Aska has reported it. What is your prayer in this?
No, sir, what a jewelry shop got Lordship. A case under section 394 411 is registered by the Aska police, Lordship. ମୋ ଦୋକାନରୁ ଏଗୁଡା ସିଜ୍ ହେଇଗଲା ମାନେ 2 silver bars, silver bar 2 kg 83 ग्राम and 1 kilo 723 kg 23 grams and 99 grams of pound, Lordship.
In this case, my lord,
I was shown as a receiver stolen for 411, Lordship.
here
I was
both
acquitted
two
from the
person, the accused as well as the informant. He is also claiming that property and he is not made a party here. He should be a party.
Where is that your
Both the petition rejected here. Analogously heard and rejected. The informant
P. Badri Prasad Patro is you.
Accused.
myself.
You are the accused in that
Yes,
case.
he
411.
acquitted in that case.
You are facing trial under which offense?
411 IPC, Lordship.
So where is that acquittal order?
Lordship.
That he has not proved.
Then how can, what is the finding?
Lordship. I'm acquitted on benefit of Lordship, but I'm given.
ସେଟା ପୁରା main ଜିନିଷଟା ଆପଣଙ୍କର ତାର ଫାଇଣ୍ଡିଂ କଣ ଆସିଲା ଆପଣ ରିସିଭର ଅଫ ଷ୍ଟୋଲେନ୍ ପ୍ରପର୍ଟି ହେଲା ଯଦି ସେଟା ହୋଲ୍ଡ କରାଯାଇଥିବ ଯେ ଏଇଟା stolen property nuhe. The matter is different. But suppose it has been held to be a stolen property and for some other reason you have been acquitted, then how can you get back that property? So for that, what is the finding? It is necessary that you should file the order of acquittal. You are only filing that order in which your 452 CRPC petition has been rejected. So that finding, I have to see that. Are you having that copy of the judgment?
Judgment copy.
So give a copy, file for the court and give a copy to the, and what he is contending, that if the two persons are claiming for the property, and that was, so you have to add the other side. You cannot pass the, because he is the informant. He is also claiming that the property is mine. So all these things can be adjudicated unless I see what is the finding given by the trial court. Why you have been acquitted, whose property was that, whether it was held to be a stolen property or the property of the informant. On that basis, it can be adjudicated. So you are not making the correct person the other side as a party, the informant as a party, who is also claiming. Number two, you are not filing that acquittal judgment, which is very much necessary in a case of this nature.
Lordship, pardon, time I've given, I filed the same in the post.
And one more thing, my lord, here 4 accused person are there. His trial was split up. In both the cases, both acquittal order passed. So he has to give both the
Both the
acquittal.
judgments. I'm
Both
submitting
the
the same in the
acquittal
post.
Okay. The learned counsel for the appellant seeks for an adjournment to file the acquittal judgment in respect of the appellant, so also in respect of the who was an accused, appellant, so also in respect of the co-accused persons. And he also submits that he will implead the informant as a as one of the respondent in this criminal appeal, as he was also claiming the property, uh, the seized properties. Hala? So put up this matter after 2 weeks, we commencing from 2nd April 2024. The Land Council for the appellant shall do the needful in filing the swansu and incorporating the informant as respondent number 2. Okay. Yes.
Item 44.
Take after lunch, man.
What is this CRLA for?
CL for matter relating to OPID Act.
Okay. Have you solved a copy on Mr.
Yes.
Bania?
Our copy now name is already reflected in the cost title.
What is your prayer in this CRLA?
Prayer is the release of vehicle.
Release of vehicle. All right, we'll take up tomorrow then. Please release this matter tomorrow. Yes.
Tomorrow, man?
Yes.
Man.
Item 45.
5, my lord.
on 15th of February.
Status report, Mr. Panda, indicates that prosecution case closed.
My lord.
313 statement recorded.
My lord.
Defense closed. And argument at the argument stage, several adjournments have been taken. And now it is also posted for argument. That is the.
Now, your lordship may kindly look at page 89 of the book.
Page 89.
My lord.
Yes.
Page 89 is the petition which was filed on behalf of the accused persons, from which this appeal arises. We filed a petition at the stage of argument, my lords, saying that, my lords may look at para. That while examining evidence of witnesses for preparing argument, it's found that prosecution has showcased 4 Jharpada jail workers, namely so-and-so as PW2, so-and-so as 8, so-and-so as 9, and so-and-so as 31, as the eyewitnesses to the murder of Jharpada jail warden Manas Naik outside his jail by firing while he was returning to barrack, having finished his duty on the relevant day, that is on AK 11/2009. Incident occurred at about 6 p.m. outside jail, whereas all 4 witnesses, including other witnesses, were by that time inside Jharpada jail till 8:05 p.m. The said incident was reported in writing by PW2 so-and-so before the IIC Lakshmisagar PS at about 7:30 p.m. on 1/11/2009, basing upon which criminal case was registered against unknown persons pertaining to such and such case number such and such under 307/34 IPC. Then your lordship may see at paragraph 3, I have again stated the FIR was prepared.
No, what is your prayer in this petition?
My lords, my prayer is, that is at page 94.
Yes.
My prayer is that the Honorable Court may be graciously pleased to examine and verify the night lock register and in and out registers of Jharpada jail dated 1/11/2009 and 4/11/2009, which are exhibited in this case in the backdrop of the contentions raised by the accused as to the unlawful act of PWs 2, 8, 9, and 31 for adducing false and fabricated evidence with intent to procure conviction of the accused persons beyond the jail register of the Jharpada jail.
No. You mean to say that 4 witnesses who were examined on behalf of the prosecution
as eyewitnesses
who
have committed perjury.
Right. So their evidence is
they should be proceeded against under one.
They have given adduced false evidence.
Yes,
on what basis you say that? Because of that some entries etc. in the that register.
Those entries establish that they were not out.
Then why did you call for those records? If you are given an opportunity at the defense stage, you could have called for the report, you could have called for the concerned authority to prove those documents, and on that basis you could have during argument
those records are there in evidence, Miller.
No, unless you argue the matter, unless you prove those documents in accordance with law, first of all there is requirement that the witnesses should be challenged on that ground, that this register is there, so that a chance of explanation is to be afforded. Second thing is that the 311 petition should have been filed to call for this the register etc. If it is not available, it should have been proved through the relevant witnesses. Then you can argue the matter that PW2 has stated be an eyewitnesses, but on the basis of these registers and this evidence, it cannot be said that he was present or he had seen the occurrence. So if that is not done, then how can straight away the witnesses be prosecuted for perjury? On what basis? Unless these documents are proved in accordance with law.
My lords may kindly look at page 20 of the brief.
Yes.
That is the cross-examination of PW2.
Yes.
Paragraph 6, my lords may look at the last line.
Yes.
The warders perform their duties shift-wise. At the time of handing over charge, warders used to put their signatures in a register. Shift duties are as follows. He has given the duties. Then, my lords may see paragraph 8 of the next page.
Yes.
Last line. During my tenure, that register was not seized by the IIC from me.
Yes.
Then your lordship may see page 22, para 12. I reached the place of occurrence at about 7:10 p.m. when the injured Manas was in the ICU.
Yes. So you can argue the matter, Mr. Panda. If you say that this occurrence took place prior to 7:10, and this, so what is the question of perjury now? If on that basis, when the witness has stated that he has reached the place of occurrence at 7:10, and prior to that the incident has taken place, then his evidence as an eyewitness cannot be believed. That you can argue, and on that basis the court may appreciate and disbelieve that witness as an eyewitness to the occurrence.
That's all right, my lord.
Yes.
But when they have committed an offense,
no,
should not they be
unless it's an exceptional thing, unless those concrete materials are brought on. Because if I give something adjudicating this matter, if I give some finding, it may goes against somebody, may go against the prosecution, may go against the accused. So it is not, it would not be proper to delve into all those things at this stage. You are free to argue the matter. Argument stage is there. So if you also intends to call for those documents, or it is available on record, you can file a petition to prove that document, or someone.
If your lordship makes those observations and I may be permitted to withdraw the petition, I think
this criminal appeal has been filed under section 341 CRPC, challenging the order dated 31/7/2023, passed by the Learned Additional Session Judge Bhubneshwar in criminal trial case number so in rejecting the petition under section 340 of CRPC to conduct a preliminary inquiry regarding the false evidence adduced by PWs 2, 8, 9, and 31. Give the names of those witnesses and initiate a criminal proceeding against them under section 195, 120B by 34 of the Indian Penal Code. The Learned Council perused the
in course of
peruse the status report submitted by the Learned Trial Court, which indicate that the case has, after the closure of the case from the prosecution side, the accused statement has been recorded, and after closure of the defense evidence, the case is now posted for argument. The Learned Council for the petitioner appellant submitted that the evidence of these aforesaid four witnesses would itself indicate that they are in fact not eyewitnesses to the occurrence, and they have adduced false evidence, and there are some material documents available on record which can also substantiate such aspect. Needless to say that when the case is posted for argument, if the Learned Defense Council argues regarding the non-acceptability of the evidence of these aforesaid four witnesses as eyewitnesses to the occurrence, the Learned Trial Court shall deal with the same in accordance with law. Any observation made in that respect at this stage would not be proper. The Learned Council for the petitioner seeks permission to withdraw the application. Accordingly, this CRLA is disposed of as withdrawn.
So,
Yes.
would your lordship make an observation that if the defense requires, documents may be brought on record?
Acha, if any material document which is stated to be available on record, and the defense wants to prove the same in accordance with law and files a petition to that effect, Allah, after hearing the other side, necessary order can be passed by the learned trial. Yes.
Much obliged.
Call these matters.
Item 47.
47, Mr. Nath.
In this case, your lordship is directed to take some instruction because the vehicle was seized during trial, NDPS case matter. He is now claiming that vehicle. Your lordship is directed to take instruction whether confiscation proceedings started or not. I have called that officer. He has just come and sitting in my office. Let it be taken up 2 weeks after, 1 week after.
1 week after. All right. The learned counsel for the state seeks for an adjournment to have some discussion with the investigating officer or the IAC.
Who has come? I do not know.
Acha,
Somebody has
the officer, police officer, you know,
excise officer.
excise officer, put up this matter 1 week after. Yes.
No problem.
Item 48.
Yes, what is this matter?
My lord, in this, the petitioner is challenging the order dated 12/9/2023 passed by the Law and Court presiding officer designated code OPID Act, my lord. And in this, my lord, the accused has been.
In this case, my lord, actually he has served copy to OPID advocate, but it is the EOW matter will appear in this case. Let him serve a copy. Let it come tomorrow. I will be ready.
Okay. You have served on OPID.
Yes.
So ask Mr. Patro to
Yes, I
hand
will
over the
take that
copy.
copy. Let it.
Or you want another copy to be given to you?
All
right. The learned counsel for the appellant, both the matters are same.
48.
Learned counsel for the all right. Learned counsel for the appellant submits that copy of the appeal memo along with the impugned judgment, impugned order, has been served inadvertently on Mr. Vivekanand Bhuya and Mr. J.P. Patra, learned special counsel appearing for the OPID Act. And in fact, in this case, the copy should have been served on the learned counsel for the state.
For the instruction by the EOW officer, yes.
Okay. Since it's a EOW matter, Mr. Patro, you should hand over the copy to the. All right. Mr. Patro, who is present in court, handed over the copy of the appeal memo to the learned counsel for the state. Okay. In court today. Put up this matter next week.
Next
then
week.
Next week. Okay. Both the matters.
Next week, madam.
Acha, your name is not required to be mentioned. The name of Mr. B. Bhuya and J.P. Patra shall not be reflected in the cause list henceforth. How can you
Next week date, madam.
it will come either. Any date. You will just give it. Okay. Yes. 44, it has been, you are not there. Of course, I have not mentioned it. It will come tomorrow. I have mentioned. Yes. 44 non-appears to much kichi lekna.
Item 50.
Next.
Contracting counsel RC Swine is ill today seriously. His
Item number?
40 dismisses. Tomorrow may come.
It has already, that order has been passed. Steno has taken dictation. You are just to file an interim application to recall that order. The Steno book is a public thing. I cannot I've already dictated an order. All right.
Ma'am.
You can file a petition to recall that order. There is no.
Ma'am.